We are used to policy disagreements that start with, "we should spend more on X," or "we need to fix Y," but they almost always end the same way. Someone drops a sentence that acts like a nuclear option: "I have a right to healthcare, housing, or a living wage." These moments are usually framed as public performances, cheerleading for a moral cause. But to understand the mechanics of liberty, we have to look past the performance and pull up the floorboards. We are peeling back the surface to see what the foundation actually looks like underneath. To perform this inspection, we need a standard of measurement. Our task is to identify what a right actually is, where it ends, and how to recognize the moment law is replaced by injury. In this framework, law is strictly a rule of right. We are looking at the structure of ownership that exists prior to any government or statute. Government does not define these boundaries. It is an agent with one legitimate end: to secure the rights that were already there before it arrived. This requires political geometry, not a debate over ideology or the weather of daily headlines, but a mechanical analysis of the blueprints, identifying the architecture of power and the jurisdictional limits of the house itself. When we apply these structural requirements, the smoke and flames of modern political scandals lose their power to confuse. Instead of looking for political saviors, we start recognizing the physics of our own liberty. Picture a blank board and draw one closed circle. This circle is not symbolic, it is an inventory. It marks the boundary within which right operates and beyond which intrusion begins. Inside the circle are four specific things. First is the body. This is the physical boundary of the person. Any crossing of the skin without lawful justification is an intrusion. It is the factual condition that makes liberty possible. A body directed by another is not free. Second is labor. This is life converted into effort. Because time is finite and irrecoverable, taking labor without consent is taking time that cannot be returned. Forced labor is an injury, regardless of the purpose for which it is demanded. Third is property, the fruit of labor. It is the evidence that time was spent and effort produced value, whether that is food grown or wages earned. To deny property while permitting labor is to permit use without ownership. Fourth is will. This is the capacity for self-direction. Without the power to choose, the other three quadrants have no meaning. Will is what makes ownership real rather than nominal. Body, labor, property, and will. These four elements are not granted by a vote or an agreement. They are the boundaries that define the individual. In this model, the circle itself is the right. To determine if a boundary is strong enough to be called an unalienable right, we check it against 5 structural requirements. If any of these bricks are missing, the wall collapses, and the claim is actually a privilege or a service. Requirement 1. It must be absolute. A right admits no degrees or mostly clauses. The Texas Constitution demonstrates this by accepting the Bill of Rights out of the general powers of government. A boundary that disappears when pressure is applied was never a boundary. Second, it must be negative. A right prohibits interference. It does not compel service. The Virginia Declaration of Rights notes that freedoms can never be restrained. A right says do not. The moment a claim requires another person to act or provide, it has crossed from a boundary into a command. Third, the cost is free to others. The Massachusetts Constitution describes the right to acquire property. This imposes no labor or expense on your neighbor. A right that functions only if someone else pays or works is not a boundary. It is an extraction. Fourth, it must be non-delegated. The Alabama Constitution notes rights are endowed by the Creator, not issued by authority. Anything that must be licensed is a permission. Anything that must be approved is conditional. Finally, a right is self-executing. It requires no application, procedural trigger, or administrative consent to function. If you must ask before acting, the boundary is not yours. It belongs to whoever grants the permission. These requirements aren't preferences. They are the geometry of law. When we mislabel a service as a right, we aren't just making a philosophical error. We are instructing the law to systematically breach the circles of others. When two individuals interact, we can map the exact threshold where a claim becomes an injury. We call this the theft line. It is the edge of the circle itself. The rule is mechanical. What costs others is not a right. If a claim requires another person's labor, property, or the overwriting of their will, it has crossed the theft line. At that point, the claim is no longer an expression of liberty. It is an injury. We often try to move this line using the will of the people, but will is not ownership, and arithmetic does not alter geometry. If one person lacks the right to take your property, 10 people do not gain that right by acting together. A crowd does not acquire rights denied to individuals, and a vote does not authorize what a right forbids. This leads to what Frederick Bastiat called legal plunder. This occurs when the law is used to take from one person what belongs to them and give it to another who did not earn it. The law stops restraining plunder and starts organizing it. We must distinguish between assessment, funds collected for the common defense of these circles, and tribute. Tribute is an exaction taken to satisfy one person's need by crossing another person's boundary. Law can either be a shield for boundaries or a mechanism for extraction. But because rights must be bounded to coexist, the law cannot structurally perform both roles at once. We can evaluate any modern political claim using a mechanical diagnostic called the pocket test. We start by stating the claim, drawing the circle around the claimant, and asking one question: whose pocket pays? If the answer is no one else's, the claim may proceed to the wall test. The right to speak, to worship, or to pursue a trade imposes no labor or expense on another. These pass. If the answer is someone else's, the claim fails immediately. No further analysis is required. If fulfilling the claim requires taking labor or property from another person without consent, the theft line has been crossed. When we run free education or affordable housing through the test, they fail. This doesn't mean those things aren't desirable or that people don't need them. It means they are structurally services or extractions, not rights. Calling a benefit a right does not make it cost-free. Mislabeling doesn't change the geometry. It only hides the injury. Accuracy in our classification is the only way to see where plunder has been normalized. This reveals an unavoidable structural tension. You cannot create a right for one person that crosses the theft line without simultaneously destroying a right in another. We can now see the inescapable conclusion of this geometry. Law is a rule of right, and whatever is contrary to that rule is an injury. The paperwork of a statute doesn't change the character of the act. This framework is often uncomfortable because it strips away the emotional slogans we use to hide extraction. It replaces the vibe of politics with the cold precision of boundaries. What costs others is not a right. We must define these boundaries with absolute clarity, because until we recognize the structural requirements of our own circles, we cannot begin to discuss what powers a government is safely allowed to wield.